Hello, my dear students. Welcome to the second part of the series on 10 static legal concepts. So, today we'll be studying the law of torts. Okay, so in the last class, we studied the major and the important topics which were based on law of contracts. In today's class, we'll see which are the most important topics as far as law of torts is concerned from the CLAT perspective. Okay, so let us begin with our class. Okay, so the first most important topic is your nuisance. Now we all know that there are certain kinds of torts. CLAT may in the past papers, in the past trend that we have seen is that there are certain topics on which they are continuously focusing. So when you go to National Law College and when you will study torts, you will study it for 6 months. Okay, so it is practically impossible to cover everything during your CLAT study. So what are those most important topics? So for from torts perspective, we have gathered a list of 10 most important topics which you cannot miss out if you are focusing for 2025 CLAT. Okay. So nuisance is one. Okay. So what is nuisance? Now, as you can see, nuisance refers to unlawful interference with a person's use or enjoyment of land or property. Okay. So the most important thing that you need to remember in law of torts, whichever tort it is unlawful. And unlawful is basically nothing but unreasonable. Okay, so under law of torts, anything that is unreasonable, it automatically becomes a case of tort. Okay, but if it's reasonable, then it is not a tort. Because see, when in a society when we are existing, it is impossible to be absolutely, perfect. Okay, it is impossible that there is perfection. Okay, there will be overlapping. People will suppose one of your neighbor is shifting. Okay, now when they are shifting, of course there will be some noise. So it is impossible that that we live in a noise free environment. Now one may say, no, we may go to the jungle. Even in the jungle, if you are going, you will hear noises of animals. So you cannot say, I don't want to hear the noise of animals. Okay, you can say that I want to go to space, I don't want to hear any noise there also. There will be noise of different celestial objects. Okay, different stars merging. And also basically you cannot live in a absolutely noise free or totally uninterrupted or independent life. We are all living in a dependent life because it's a community. So why this is important is when there is reasonable interference, then it is never nuisance or never any kind of tort. Only when it is unreasonable, something which is away or something which is totally different from what are the norms of that society, then do we classify it as a tort. So this unreasonable part is applicable for all torts. Okay. This not just applies in case of nuisance, it will apply in all torts. So make this a note. Whenever any tort case is there and you need to make it a successful tort case, it has to be 100% unreasonable. If it's a reasonable interference, then it is never a tort, whether we talk about nuisance, negligence, or any other tort. Okay. So let's come to the second point. It is categorized into two: public nuisance, which affects the community or a significant number of people. So suppose and private nuisance, which affects an individual's right. Now suppose two people are living. If only one person is getting affected, it becomes a private nuisance. If more than one, as in the public at large, suppose a railway track is being laid, okay, and there are at least 50, 60 houses in the vicinity and they are getting affected, then it becomes a public nuisance if it is unreasonable. That thing is always to be noted. To constitute a nuisance, the interference must be substantial and unreasonable. This is what I mentioned in the beginning. Okay, that unreasonable. If it's reasonable, then you cannot file a case. Not merely a trivial annoyance. Okay, the injured party can seek damages or an injunction to stop the nuisance. Okay, so damages is nothing but your compensation. Okay, an injunction is an order by the court to stop that wrongful activity. Okay. Examples include excessive noise, pollution, obstruction of public ways, etc. There can be thousands of other examples. Okay. So let us move to the second important topic, which is your negligence. This is the second most important kind of tort on which CLAT has tested students. Negligence under the law of torts refers to the failure to exercise reasonable, now again the word reasonable care resulting in harm and injury to another person. It arises when one party owes a duty of care, okay, one, breaches that duty, second requirement, and causes damage as a direct result of such an activity. So there are basically three requirements to constitute a successful case of negligence. The elements of negligence include duty, breach, causation, and damages. Okay. So what is written here, they have summarized it in these points. So if one is missing, suppose there's no duty of care, then you cannot bring a case of negligence. So the three essential ingredients must be there. So in the exam, when they will test you, they will give all the requirements. Okay. So in the passage, they will mention this only can be given as a passage. What you see in front of your screen, and then questions can be given around this. Okay, let us read further. A negligent act can be an omission or a failure to act when there is a legal duty to do so. Now, there may be an act which we call a positive act, an omission or a failure to do an act, let's say a negative act. Let's say you are living in your house and there is a tree which is growing in your compound. Now, the branches of the tree are venturing into the house of another guy who is your neighbor. Now, here your duty, your omission to cut the branches of the tree to the extent that they do not reach your neighbor's house, to such extent you are liable for negligence. Okay, so even a omission or an act which you are legally supposed to do, but if you omit to do, even that can be negligence. You cannot say that no, I did not do anything, why am I being held liable for negligence? You cannot say like that. You cannot take that defense. Okay. Common examples include car accidents, medical malpractices, or workplace injuries. Victims of negligence can seek compensation for the harm suffered. Okay, so compensation is the remedy for all civil wrongs under all cases of tort. If you are able to establish a correct case, if the judge agrees that yes, there was a reason unreasonable interference with your rights, and you win that case, there will be compensation. So that is the point of civil law, that you are awarded compensation for the wrongful act or the wrongful damages that you suffered. Now, the third tort, or the third most important topic for your CLAT preparation under law of torts, is trespass. Trespass under law of torts is the unlawful and intentional or unintentional, whether it is intentional or unintentional is irrelevant, interference with another person's property, either land or goods, without permission or without legal justification. It includes trespass to land, where someone physically enters or causes an object to enter another's property without consent, and trespass to goods, involving the unauthorized handling or interference with someone's personal property. Let us take an example. Suppose two people are living. Now you are here. You threw a stone in your neighbor's house. Even that is trespass. Read this line. Where someone physically enters or causes an object to enter another's property. So even if you are not entering, but you're throwing that stone and you're causing a property, which is a stone, to enter into your neighbor's house, even then your neighbor can say that you have committed trespass and you have to pay compensation to your neighbor. Okay. So the trespass can be by both your own self or by a good. Okay. Also, it can be to a good. So if you are entering the property, or if you are mishandling someone else's movable property, then also there can be trespass, which is called trespass to goods. Okay, which involves unauthorized handling or interference with someone's personal property. Suppose someone's mobile is kept and you go and you throw it, okay, or you start playing with it, or you remove its cover, or you do something in it. You uninstall an app or you install an app. Even that is trespass. Why? Because that is unauthorized handling. Who told you to touch your neighbor's phone? Okay. Now, if it's a brother, sister, or if it's a friend, then it's okay because it's a social setting. But if it is an unknown person, then it is unauthorized handling. Okay, you will be liable for trespass. So be careful. Trespass can occur even without causing actual harm or damage, as it protects the right to exclusive possession. So when you are entering into someone's house, you are not actually harming that person, but even then, it is a trespass. Why? Because the right has been infringed. Whether the actual damage occur or not is irrelevant. The injured party can seek damages or an injunction, just like in the case of nuisance and negligence, to prevent further trespass. It is distinct from negligence as the key intent, as intent is key in trespass. Okay. So this is one of the distinction, but not necessary, because you may unintentionally also enter into someone's property, and then also it is trespass. So intention, whether it is there or not, for now you can ignore that. Okay, because uh, such kind of nuanced understanding generally is not tested in CLAT. They will test you on the surface. They don't go too much deep. That you go when you go to National Law College. Okay, so let's move to the next point, which is a defamation. Okay, defamation is the fourth most important topic and fourth most important tort under law of tort. Defamation under the law of tort refers to the act of making a false statement that harms the reputation of an individual, business, or entity. So the statement has to be false. If it's a true statement, then there is no defamation. Secondly, there has to be a harm to the reputation. It is categorized into two types: libel, which is written or published, and slander, which is spoken. For a statement to be defamatory, it must be false, requirement number one, communicated to the third party, requirement number two, and result in damage to the victim's reputation, requirement number three. Like in negligence, we saw that there were certain requirements or there were certain essentials. Similarly, under law of torts, these requirements are present under law of defamation, as in law of tort, which is defamation. Truth and privileged communication are common defenses against defamation. Okay. So, of course, it has to be a false statement. If it's a true statement, it is not defamation. So, truth and privileged communication are defenses. Privileged communication are generally a parliamentary proceedings. The injured party can seek damages to compensate for harm to their reputation, emotional distress, or financial losses caused by the defamatory statement. Okay, for to the reputation, emotional. Okay, so these things are common in all torts. Okay, so these were the essentials for defamation. Now let us come to the next important topic for your torts. Okay, now this is master servant relationship. The master servant relationship concept under the law of torts establishes the legal relationship where a master is held liable for the wrongful acts or torts committed by the servant or employee during the course of employment. Now, here the important term is course of employment. This principle, known as vicarious liability, applies when the servant's actions are within the scope of their duties and intended to further the employer's interests. The rationale is that the master controls the servant's work and benefits from it, thus should bear the responsibility of any harm caused. Of course, whatever the servant is doing, the master is benefiting. So if there's some act that the servant does during the course of employment which is negligent or which is nuisance causing or which is trespass, the master also can be held liable for that. Okay. Common examples include employer liability for employees' negligence, such as accidents or misconduct at work. Hmm. Here, the most common example that in several times in CLAT papers, if you see the past papers they have asked, is the driver. So the master has a servant. He asks the servant to get one of your relatives from the airport and come back to the house. Now, when the driver was driving, he crosses the speed limit in order to reach fast at the destination. Okay, because of this driving, in a rush, he injures another guy who was crossing the road. Hmm. Now, this guy who is injured, he will of course file a case of negligence against the driver, but he can also file a case against the master, okay, on behalf of vicarious liability, because the servant is doing the wrongful act, okay, which and the person who's injured, he can hold the master also liable. So this is the master servant liability, which is a concept under vicarious liability, which says that if for any negligent or wrongful tortious activities of the servant, the master can be held vicariously liable if it's done during the course of employment. Okay. So here the most important point is course of employment. So if the servant does a wrongful activity or a tortious activity after the course of employment, or while he is not in the course of employment, then we cannot hold the master liable. Okay. So similarly, if the same driving activity was done after the office hours and the servant is going out with his friends and roaming somewhere, and he speeds his car and he hits someone, or he speeds his bike and hits someone. Now that guy who is injured, he cannot bring a case against the master, because now the course of employment has ended and the servant is acting independently. So the most, or one of the most important distinction that you need to remember when you are holding the master vicariously liable for the acts of the servant is that the acts for which the master will be vicariously liable of the servant must be during the course of employment. If they are outside the course of employment, howsoever big or small the negligent acts are, you cannot hold the master liable. Why? Because then for every act, now there is a logic for that also. If you hold the master liable, then the master will never hire a servant. He'll always be scared, what if he does something, what if he does something like that. So we hold the master liable only to the extent that the servant was acting in the course of employment. Hmm. Many students get confused in this concept. Okay, so don't get confused. The point is that if it's done during the course of employment, master is liable. If it outside the course of employment, master is not liable. Okay, so let's move to the next topic, which is the principal agent relationship. Now here also it is very much similar to the master servant relationship, but there is a difference. Okay, the principal agent concept under law of torts involves a legal relationship where one party is authorized to act on behalf of another. Okay, now in a master servant relationship, it is more of a menial, or we can't say menial, every job is important. It is basically your more of household jobs like driver, cook, maid, those kind of things. Principal agent is more of a white collar job. The job is similar, as in the work that the agent does for principal or the servant does for the master is more or less similar. It is only the kind of job that we create this distinction. So, for example, there are three people, A, B, and C. Okay, and they are in a partnership. Now, C enters into a contract with D on behalf of the partnership firm that A, B, and C operate. Now, here, if in future there is a problem and D wants to sue the partnership firm, he can sue A, B, and C all three together. Here, A and B cannot say that we did not sign a contract with you and now you cannot sue us. He can. Why? Because of the principal agent relationship. Because when C is signing the contract with D, he is acting as a agent of A and B, and they are his principal. So the agent will bind the principal as if the principal acted himself. So it will be presumed under law that A and B also went and signed the contract with D. Similar, whatever ramification would occur if A and B themselves went and signed the agreement, similar ramifications will occur when C acted on behalf of principal A and B as an agent. Okay, so this is the concept. So you can hold the principal liable for the tortious activities of the agent. Again, done during the course of employment. This is again important. Course of employment as in related to the business work of the principal. So not for personal work of agent. Okay, just like in master servant. The principal can be held liable for the wrongful acts or omissions of the agent, provided those acts are within the scope of agent's authority and in the course of their duties. Okay, course of their duties or course of employment, one and the same thing. This is also a form of vicarious liability, just like master servant. The principal is responsible for torts committed by the agents when acting on instructions or for their benefit. So, this is giving a definition of course of employment. Common examples include business transactions or legal representations conducted by an agent for the principal. Okay. So now let's move to the next example or the next topic, which is most important. So independent contractor. Now these three topics are interrelated. So master servant, principal agent, and your independent contractor. You have to study them together. It will be easier if you study together. Now, what is the difference? So here, in the previous two topics, we mentioned that the master is liable for the acts of the servant and the principal is liable for the acts of the agent. This is the vicarious liability concept. When it's an independent contractor, so when someone X person is hiring an independent contractor, if the independent contractor is doing a wrongful act, negligent or nuisance, and it is resulting in a tort which is injuring some other party, this party cannot file a case against the X, because this person who did the act is an independent contractor. If this person was a servant, then X could be held liable saying that he is a master. Or if this person was the agent, then X can be held liable saying that he was the principal. But when he is an independent contractor, you cannot hold the person who employed the independent or who hired the independent contractor liable. So, what is this concept? The independent contractor concept under the law of torts refers to the legal relationship when a person or entity is hired to perform specific work but operates independently without direct control from the third hiring party. Okay. So the difference here is, so when in principal and agent relationship, when the agent is acting, he is acting on direct authority of P. Similarly, when S is acting, the servant is acting on behalf of the master. He is acting on direct authority of master and he is under direct control of the master. Whatever the master says, the servant has to do. Whereas in independent contractor, you are just hiring that person, but that person will perform his work independently and not like a agent of yours or not like a servant. Unlike an employee, an independent contractor controls how the work is done. Generally, the principal is not vicariously liable for the torts committed by an independent contractor unless the work involves inherently dangerous or non-delegable duties. Liability typically rests with the contractor for their negligent act. So you cannot hold the master or the principal or the person. We cannot call them master or principal also, because the person is independent. So the X person who's hiring an independent contractor, X cannot be held liable. Okay, because this is an independent contractor. Let us see a few examples. So examples are doctors, let's say lawyers, okay, architects. So if you hire an architect to do some work, and the architect, because of his negligence, constructs a wrong design, because of which some parties are hurt, those parties cannot file a case against you. They can file a case of tort of negligence against the architect, but they cannot hold vicariously liable. You cannot vicariously hold you liable. Why? Because the architect is not your agent or he is not your servant. He is an independent contractor. So independent contractor can also be seen the another way of stating independent contractor is an exception to vicarious liability, or an exception to master servant relationship, or an exception to principal agent relation. Whichever way you see it, the only point that you need to remember for CLAT is that master servant and principal agent, these relationships fall within vicarious liability, and independent contractor is a separate uh, entity altogether. That's why the name also independent. Okay, so let's come to the next topic now, general defenses. So we all know that there are 8 general defenses that are available in tort: consent, VNFI, self-defense, necessity, inevitable accident, statutory authority, act of God, and contributory negligence. So read them. Consent, if you are consenting, VNFI, most commonly tested thing. So the best example is cricket stadium. If you're going to watch a cricket match and you suffer an injury because the ball lands in the stadium because the batsman hits a six, you cannot file a case against the stadium authority. Why? Your act of going to the stadium itself is a VNFI. You are voluntarily agreeing to suffer that risk. Okay, so the stadium authorities can get this defense. You cannot say that the batsman is liable for trespass or nuisance. Self-defense. So if someone is coming to you, okay, or if someone is committing a tort, but in order to defend yourself, you're using self-defense, then the person cannot hold you liable for tortious activity. Necessity, suppose you are trespassing to douse the fire in your neighbor's house, that is a necessity. Inevitable accident, let's say the car brakes fail, even with your if you got your car service regularly, in spite of that, due to some manufacturing defect, the car brakes fail and you meet with an accident and injure someone. Now that person will file a case of negligence or trespass against you. You can take the defense of inevitable accident, saying that by my car brakes failed despite I having taken reasonable care, so I cannot be held liable, and you will get that defense. Statutory authority are acts done by law, generally by government agencies. Act of God, suppose there's an earthquake, flood, or any other acts of God, tsunamis. In such a case, you cannot be held liable, or you can take this defense. And contributory negligence, the person who is filing a case against you, he himself contributed to that negligence, okay, or to that tort. In such a case, you cannot be held liable, or you can get a defense. Okay, so these are the 8 defenses. You can read them in detail. Now let us come to the second last topic for today's discussion, which is strict liability. Okay. Strict liability under law of torts holds a person or entity responsible for harm caused by certain activities regardless of fault or intent. Okay. So that's why this is also known as no fault liability. Why? Because despite there being no fault or intent, you are still being held liable. And so the name strict liability. It applies when someone engages in inherently dangerous or risky activity. So the activity is not normal. For normal activities, strict liability will not be applicable. It is applicable in cases of inherently dangerous or risky activity. Suppose a chemical industry is operating, inherently dangerous. Suppose some other activity, you are sky jumping, risky activity. Strict liability is applicable. And if they cause damage, the defendant is liable even if all precautions were taken. The classic case is Ryland versus Fletcher. This is one of the most commonly cited cases where a person was held liable for damage caused by the escape of hazardous substance from their property. So it was a water tank that was constructed, and despite taking reasonable care, the water tank exploded, which flooded the mines of the plaintiff, and he filed a case against the defendant. Common examples include harms caused by keeping dangerous animals or using explosives. Suppose now Diwali time is coming. So now suppose there are firecrackers, okay, and there is an explosion. This is an inherently dangerous activity. So even if you have taken all the care, you'll still be held liable. Similarly, if you're keeping a crocodile or any other dangerous animal, you can be held liable. Strict liability ensures victims can recover damages without proving negligence or intent. Okay. Let us come to the next topic, which is absolute liability. Absolute liability under the law of torts is a stricter form of liability. So, strict liability is this strict, then absolute liability is this strict, more. Okay, so it is a stricter form of liability where a person or entity is held responsible for harm caused by hazardous activities without any defense. So, under strict liability, there are five defenses which are available. So, the common defenses are different. For specific of torts, there are specific defenses. So for strict liability, there are five defenses, but for absolute liability, there are no defenses. Unlike strict liability, under absolute liability, no exceptions are allowed, even for acts of God or third party intervention. So these are exceptions under strict liability. The principle was established in MC Mehta versus Union of India case following a gas leak from a factory. This applies to industries or activities involving dangerous substances that pose serious risk to the public or the environment. The aim is to ensure maximum protection by holding operators fully accountable for any resulting harm. So strict liability was a concept that originated in UK. So the Indian courts in this case, they said that if we apply strict liability, then the defendants can take the defense of acts of God or third party intervention, and certain other defenses are available. This will result in injustice to a lot of people, and many companies which are acting in dangerous substances and earning huge profits, they will go scot free. So the court modified the strict liability concept, the Indian Supreme Court, and laid the foundation of absolute liability. So absolute liability is a Indian origin concept, not a foreign concept. So depending upon Indian circumstances, this concept originated. So the only difference between strict liability and absolute liability is under absolute liability there are no defenses, while under strict liability there are five defenses. So no need to mug up. Again, I need to clarify to all students: don't mug up any point. Just understand all these that you see in front of you. If there is a case, if there is a concept, every explanation will be given in front of you. It will be in front of you in the passage. You just need to apply that information to the facts given. So understanding an analytical mind is more important rather than the mugging mind. Okay, so no need to worry. Even if you cannot remember it absolutely, it will be given in the passage. You just need to understand that absolute liability means there is no defense. That means the person will be absolutely liable. But you also need to understand that there has to be a hazardous activity. Suppose there's no hazardous activity, then absolute liability will not apply. So according to the fact, if someone is keeping a pet, a normal dog, then that is, in such case, absolute liability cannot apply. But if there is a factory which is operating in a very lethal gas which can cause death of thousands of people, then absolute liability can apply in case there is a gas leak. You understand? Okay, so this ends the discussion on absolute liability. In case you have any doubts or any questions, you can ask me. You can reply in the chat box. I'll be happy to answer. Okay, so thank you everyone. It was a nice interaction with you guys. Okay, so I have one question. Sir, in legal reasoning, we have a similar answer means same meaning answers. How to clear? Okay, okay. Sir, in legal reasoning, we have a similar answers means same meaning answers. How to clear? Okay, so Pedada Malleshwari. So Malleshwari, P Malleshwari, you have to choose the best option. So that is the trick that the examiner plays. It is done intentionally to confuse you. You have to see that option which is linking the facts to the passage and not to any external knowledge. Generally, this is how they confuse you. Okay, so this is an intentional way to divert you. Otherwise, every student will get 35 out of 35 marks. You understand? So the this is the aim of the examiner. that I need to confuse the students and see which student has understood the concept properly. Okay. So in case you are able to eliminate two options and you're stuck between two similar options, try to see which option is more closer to the passage. Okay. And this you learn by practice. Okay. So if there are more questions, you can always reply in the chat box and I'll be happy to answer. Bye students. We'll meet in the next class when we'll have the third part of our discussion on static concepts for CLAT. Bye bye. Take care.